48. What are the 10 most common interviewing questions that could cause legal problems?
No discussion of interviewing would be complete without at least a partial listing of the most problematic interviewing queries that could land companies in legal hot water. Usually these are questions that are, or can be perceived as, breaking laws against discrimination. No one sets out to ask discriminatory questions. Sometimes it's just out of oversight that managers ask inappropriate questions. For example, a hospital administrator in a pathology laboratory interviewed a female candidate who was obviously pregnant. The administrator was concerned that the chemicals in the lab, which were known to cause cancer, could adversely affect the fetus. Out of concern, the supervisor asked the candidate, "Are you sure you'd want a job that exposed you to cancer-causing chemicals, especially now that you're pregnant?" When the candidate was not ultimately selected for the position, she brought her complaint of discrimination to the hospital's Human Resources Department. The department promptly invited the candidate back to interview for other openings and apologized for the hospital administrator's indiscretion. Although no further legal action was taken, a more aggressive individual might have pursued the matter further. The administrator, in his defense, stated that he was asking out of practical concern and meant no harm or offense. He was written up nonetheless. Companies have an obligation to demonstrate that they take such concerns seriously and provide remedial training and, when necessary, discipline to prevent further incidents of inappropriate questioning. Tell me more. So which questions do you have to watch out for? After all, you realize that your intentions, harmless and innocuous though they may be, are not at issue. It's a plaintiff attorney's interpretation of your questions that's the real issue. And it's not uncommon for plaintiff lawyers to attribute unlawful motives to your actions by making a case that you've used the information that you learned by asking a particular question to unlawfully deny the candidate employment. To avoid legal skirmishes of this sort, review this partial watch list that follows, and ensure that these questions never make their way into your interviewing vocabulary. Inappropriate question number 1. What's your maiden name so that I can check your references? Asking for a woman's maiden name can discriminate against her on the basis of marital status and possibly national origin. Instead, ask whether the candidate has used any other names in the past, not necessarily due to marriage, that will allow your company to verify the person's past work experience and education. Inappropriate question number 2. How old are you? A variation of this question is, in what year did you graduate from high school? State and federal law protects workers more than 40 years of age. There's no problem asking about the year in which a candidate graduated from college. People can graduate from college at any point in their lives. In contrast, nearly all high schoolers graduate at about 18. An individual's year of birth could readily be determined by subtracting 18 from the year of graduation. Inappropriate question number 3. Where were you born? Are you a U.S. citizen? Where did you learn to speak Spanish? These questions transgress guidelines regarding national origin, birthplace, and citizenship. Instead, you should ask, could you, after employment, submit verification of your legal right to work in the United States? Questions regarding a candidate's native language or acquisition of foreign languages should generally be avoided unless such language proficiency is an essential function of the particular position being applied for. Inappropriate question number 4. Are you married? Can you make adequate provisions for child care? Oh oops, a big no-no. It's a legitimate concern to wonder whether a potential employee can meet overtime demands, fly out of town on last-minute notice, or consistently report to work on time. However, You are limited by law to stating such things as standard working hours, any overtime demands, and company travel expectations, and then simply questioning whether candidates would have any reason why they couldn't meet those requirements. Inappropriate question number 5. Would your religion prevent you from working weekends? Asking such a question discriminates on the basis of religious affiliation. It's just as easy and effective to state, weekend and holiday work is required. Is that acceptable to you as a condition of employment? Inappropriate question number 6. Are you disabled? Have you ever filed a workers' comp claim? How many days were you sick last year? Do you have AIDS? The Americans with Disabilities Act of 1992 requires businesses with 15 or more employees to make their facilities accessible to the physically and mentally disabled and prohibits job discrimination on the basis of disability. The ADA says that a company can't exclude a qualified candidate from a job if that individual can perform the essential functions of the job either unaided or with a reasonable accommodation. The terms in quotation marks are subject to legal interpretation, of course. The alternative? Hand a candidate a job description that differentiates essential and non-essential job functions, and ask, are you capable of performing the position's essential job functions with or without a reasonable accommodation?